Yeah,
We haven't gone live yet.
Oh,
You good, we're live.
they built on it.
Mr. Chairman, we're set now. We're all set now.
Okay. So I will call this special meeting of the Zoning and Planning Board of Review to order. Heidi, could you call the roll, please?
Yes. Christine Brochu,
Here.
Ellen Cornell,
Here.
Keith Kyle,
Here.
Christopher Allman,
Here.
Anthony Brunetti,
Absent with cause.
James Manning.
I am here.
Mr. Chairman, you have 5 members present. You have a quorum.
Thank you. So we're here this evening. Actually, first thing on the agenda, I saw Christine raise her hand, so, to be the secretary this evening. So thank you for volunteering.
My turn, I don't know if I saw your hand
Appreciate
go up.
that. I'm sure you do a wonderful job. So we're here this evening. It's an appeal of the building official's decision. Nuttall Properties, Plat S, Lot 90, 11 D Felice Road. It's a notice of violation of the town zoning ordinances issued by the zoning official. So, Mr. Zangari, good evening.
Good
You
evening,
have
Mr.
the
Chairman.
floor.
Thank you very much, members of the zoning board. My name is Christopher Zangari. I represent the town of Narragansett. Strike that. I represent Wayne Pimentel, the building official for the town of Narragansett, in the appeal of his notice of violation dated September 12th, 2013. September 13th, 2023. I'm going to be presenting 2 witnesses this evening. One is Mr. Pimentel. One is Mr. Eidelman, who's the zoning enforcement officer. So I'll start with Mr. Pimentel. If you could come up and be sworn in, please.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
Sure. Wayne Pimentel, P-I-M-E-N-T-A-L.
Thank you.
Mr. Pimentel, who is your employer?
The town of Narragansett.
What capacity do you work for the town?
As the building and zoning official,
How many years have you done that?
3.5.
And is one of your duties as the building official for the town of Narragansett to issue notices of violation? And when I say notices of violation, I mean violations of the town ordinances and codes.
Yes.
Did you have a chance to do that regarding the property located at 11 D Felice Road in Narragansett?
Yes, I do.
Are you also the keeper of records for the building department in the town of Narragansett?
Yes, I am.
Are the building records in the town of Narragansett kept contemporaneously with the events depicted in those records?
Yes, they are.
And is it the normal and usual course of business for your department to keep such records?
Yes.
I'm going to show you what we're going to mark as, would you like towns 1 or towns A?
1.
Towns 1. And you're going to mark, actually. I'm going to show you what we're going to mark as towns 1. These are 2 sets of documents. Right. The first one's a shorter packet. It's got November 13th, 2023 in the right-hand corner. Do you see that document?
Yes, I do.
Let me give these also to. What's that? Oh, I gave you extras. Sorry about that.
I just didn't want
Yeah, that's right. Pass around to the board. You take one of each.
This is all T1.
This is, yeah, they're gonna both be two. You recognize that first document with the date November 13th, 2023?
Yes, I do. Yes, I do.
And what is that?
That is the record, the complaint record that we keep for all complaints in the office, and with that is any correspondence related to the complaint, to the violation.
And who issued that report?
Larry Edelman?
And Larry is the zoning enforcement officer for the town, correct?
Yeah, zoning and rental enforcement.
The second batch of documents there, it says Nuttall on top of handwriting. Can you tell us what that package contains, please?
That contains, again, the initial inspection, complaint form, all correspondence that Larry, his notes that he compiled in the investigation of that violation, the violation
Mr.
letter
Chairman?
that I issued.
There's some confusion with the exhibits that were submitted because they're all stapled together. Is that correct?
Yes.
Okay.
So what Wayne's doing is he's gonna tell you all the things that are in that stapled package.
Are,
It's a two-page
one
package.
exhibit?
There's two, and then there's one that's thicker.
Can I have Christine?
I only
on
have the
that,
two-page
please?
packet. I mean, two
Because
page,
she didn't, you've only got the
two-pager.
2 pages.
I already wrote on
Take that one.
Yeah, here's another one, here's another.
Thank you.
Oh, okay.
This is complete all to one.
Just so we get it.
Thank you.
That thicker part, that thicker package, Mr. Pimentel, could you again tell the board what that contains?
Here it is.
That contains
A little
the
bump full, isn't it? Oh, okay.
the electronic complaint inspection report, all of the notes Mr. Edelman had taken during his investigation of that complaint. It also contains the violation letter that was issued to the homeowner for the violation of the ordinance. And
There's also the letter from the owner's counsel, Mr. Serda.
That's correct.
Okay. And does it also contain copies of the return receipt green cards and receipts that were mailed to the homeowner?
Yes, it does.
All right. So that's the record of this case, correct? The written record.
That is correct.
Thank you, Mr. Pimentel. I'll bring on Mr. Edelman to talk about the actual particulars.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
Larry Eidelman, Eidelman.
Thank you.
Mr. Edelman, who do you work for?
Town of Narragansett,
For how long?
for almost a year now.
In what capacity?
I am the code enforcement and housing inspector for the building department.
Is one of the duties that you have as a code enforcement officer to investigate complaints?
Yes,
And did you investigate a complaint on November 12th regarding the property located at 11 De Felice Road?
not on November,
I strike that, on September,
September 12th.
September 12th, thank you.
I did,
All right, that was 11 De Felice Road.
correct.
And did you come in contact with anybody when you knocked on the door at 11 De Felice?
I did.
Who did you come in contact with?
Several young female homeowners.
And did you ask them any questions?
I asked if the property was a rental property.
Did you get a response?
They said it was.
Did you ask them any other questions?
I asked how many of them were currently renting the property.
And when you were asking these questions, where were you? Were you at the front door?
Standing outside the front door.
And were they within the threshold?
They were all in one large room downstairs,
And-
moving around.
And how close were you to them?
To some of them immediately, to others a few feet.
So when you were asking these questions and receiving these responses, how many were you addressing your questions to?
At least 3, and I believe that sometimes there was a 4th female.
When you asked the question if they were renters, you received a response from one or all of them?
Directly from one of them.
Did any of the others that were standing there dispute that answer and say, no, I'm not a renter?
No.
Did you ask any other questions?
They asked to see a copy of the lease.
Did you receive a response?
They said there was not one available.
Did you ask them any other questions?
I asked how many of them were renting there.
What was the response?
They said 8. I asked if any of...
Let me,
I'm sorry.
That's okay. You received that response from one or more of the women standing in front of you?
Definitely from one.
Did any of the others that were standing next to her dispute the fact dispute the answer that was given by the one?
No.
Did you ask any further questions?
I asked of the 8, or I said, 8, are any of you related?
What was the response you got, if any?
No.
What did you do after that?
I asked, how many bedrooms are in the house?
What was the response you got, if any?
8.
Did you follow up with any further questions?
I asked if they were aware that the house was not currently registered.
What was the response you got, if any?
They did not know.
What did you do after that, after you received those responses? Strike that, let me go back. When you received those responses, did any of them dispute the answer given by whoever was responding?
No.
What did you do, if anything, after that, after you received those responses?
Once it was determined they couldn't provide a lease, I had no further questions for them, so I left my business card and I left the premises.
Where did you go after that?
I believe directly back to my office.
Did you compile a report?
I did.
How soon after you had the conversations with those 3 young women at 11D Police did you compile that report?
Probably within an hour and a half.
Is that report reflected in Town's Exhibit 1?
It is.
Did you have a chance to review that report before you testified this evening?
I did.
Is there anything in there that is inaccurate or that you would like to change?
Absolutely not.
Is there anything else that you want to add?
No.
That's all I have for Mr. Hyde.
I just have one question, sir. When you were on the property, were there any vehicles parked in the driveway?
Yeah, there were, I believe it's in my report, actually. Upon my arrival, 4 vehicles in the driveway upon my arrival.
Did they all have same or different registrations?
I do not remember. I normally do not make note of that. I can if you would like me to in the future.
Just curious whether you noticed that.
It's usually the case that they do, but I don't know specifically with this that they were.
Actually, do you want to take a look at your report? Because I think you may have made note of this. Maybe that's
If
where
it's in my
read it.
report, I made note of
read
it,
last
just
night
a
or
long time
something.
ago.
So if you look at your report, you
Notice 4 vehicles in the driveway, each with
No,
registration.
Wait a minute,
read yourself. Read
Okay.
yourself.
Okay,
Yeah, does that refresh your recollection?
It
as to-
does,
All right,
sir.
can you tell me what you observed?
it does. So I observed that they had registrations from various states.
Thanks.
Thank you.
Are there any further questions of this witness? No. Thank you.
Thank
Thank
you.
you. That's all the town has at this point.
Okay. Thank you, Mr. Zingari.
So, Mr. Manning, obviously Mr. Serta can put on whatever direct case he wants, and in this case, should he wish to cross-examine either official, he should have the right.
Thank you, Mr. Chairman, members of the board. Thank you for holding a special meeting tonight. I know many of you are busy, and thank you for taking time out of your day to do that.
You're welcome.
I have, I think, one additional exhibit, which I'm going to call appellants. Do you want to do A or 1? Whatever you prefer.
A1.
Okay. For the record, and I have copies for board members as well.
Thank you.
Thank you.
I would, as you said, mark this as A1. For the record, you'll see that this is appellant's lease. You will note that the lease is not actually executed by anyone on behalf of Mattel Properties, as Mattel Properties purchased the property after this lease was in place. And thus, by the nature of Brown law and land use, they were bound by this lease upon purchasing the property. This lease was already in place, and it's something they were bound with. I would direct you to page 2, as well as the initialing on the bottom of almost every page and note that there are 3 leasees that have signed this lease and initialed each and every page. I will also direct your attention to certain provisions within that lease, if you'll permit me to do that. Let's see, specifically page 3, paragraph number 13, where you'll note that the landlords in this case are not permitting any lease or sublease of the premises without the landlord's prior written consent, which I have been not been provided with any documentation where that was provided either by the initial landlord or by Mattel Properties. And I would note that in the questions that were asked by the town investigator, there was no discussion of subleasing. There was no discussion of whether or not whomever he was speaking to had a lease directly with the owner of the property, and who they were tenants of, which I think is very relevant here in that this inspection occurred on September 11th, I believe, or September 12th. I apologize, thank you, September 12th. This lease you'll see starts on September 5th. So to suggest that the owners of the property, if there was a sublease going on, would know or have knowledge or been able to obtain that in a approximately 1 week or less period is a substantial burden to place on a landlord, or place on a property owner in that regard. When they have a validly executed lease that meets all the criteria of your statute. In fact, is one less person than the statute allows. And I will recall the inspector to confirm that he did not ask if all of those tenants had a lease, if they intended to remain there for the entire, how long they were at least lasted for, and who their landlord or who their lease was, or who the leaseor is. Reason being, my clients, under the contract Mattel Properties, have a lease with 3 folks, which is in compliance with your statute. I would also direct you to page 6, specifically paragraph number, I'm sorry, look on the wrong page, that was wrong. I'm sorry, yeah. On page 6, paragraphs A primarily, where in order, again, to insulate themselves and to be assured that this is the only parties that they are leasing to, and to be clear that no other parties are allowed to be at the premises by permission of the landlord, this lease denotes that only payment from the 3 individuals, only 3 forms of payment will be accepted by the landlord. Again, acting as a lease and acting as a legally binding contract to facilitate and make clear that the owner of the property only leased to 3 people. So I would ask an opportunity to ask questions of your inspector at this time, if you permit me to do so.
Sure.
Please, if you have
Just,
questions first, please go ahead.
So just doing simple math, if you're talking 3 people are leasing this house at the rate that they're charging, you're trying to tell the board that they're paying $2,400 a month for their,
That's what these statutes are gonna create. They're creating a scenario, and you'll find it amongst all of the property managing entities. The people have carrying costs for these properties. People have taxes, people have utility expenses, they have mortgage expenses. Their expenses aren't gonna change based upon the ordinances that the town enacts. As always, the burden is gonna fall on the lowest level consumer. It's
I fully understand that, but I find it hard to believe that someone is going into a lease from a practical standpoint, and they're paying $2,400 a person based on 3 people for an 8-bedroom home.
This is it's a high-end home.
Okay.
There are 3 very big, beautiful bedrooms that look out towards the ocean at the top, is my understanding. I haven't had the chance to go in the premises. And that was the lease that was entered into. If there's a sublease, if those tenants take that on and do something in violation of this lease, they bear that legal burden and the consequences associated with that. And further, like I said, this lease was inherited by my clients. So they did not negotiate it. It was locked into place. They purchased the property after the lease was executed, and thus we're stuck with it.
When did your clients close on this property?
I believe in 6/2, so sometime in the middle of summer. And common practice with students is to have the premises rented prior to the close of the prior semester.
And
6/2, what year?
Oh, I'm sorry, 6/2 of 2023. So it would have been, this would have been occurring in September of 2023.
does their purchase and sales agreement say they're purchasing this property subject to this lease?
Yes, it does.
And did they see the lease before they closed on the property?
I can't speak to that either way. I don't know the answer to that question.
Because I just want to, when I looked at it, I guess what do you have to say about paragraph 18 where they're saying that the landlord authorizes tenant to park 8 properly registered working motor vehicles?
Well, that would be, there are an opportunity for guests to come, significant others, family members. So, and we have, and as we know in this town, there's been significant issues with cars parking in lawns, cars parking everywhere. So there's a hard limit to the number of vehicles that can be there to not, it's a relatively small lot, it's a congested area, to not have that become a parking lot, quite frankly.
All right, so I just want to make sure, because I think this is a very novel argument you're making, and I want to see it probably is going on around the town. So this lease was entered into before at the time your clients purchased the property. So they purchased it subject to this lease. And it had a certain rental payment, which I think what you're saying is reflective of the fact that they have all these carrying costs and et cetera, and they wouldn't be able to otherwise afford it without having the rents at whatever rate they are. And then these 3 tenants, you believe, or your client believes, sublet to additional people to cover that cost. I mean, I'm just trying to understand. That's the theory of what you're saying.
It's a possibility, yes. Well, I can't speak to what they did. I don't have any evidence of it, nor was it inquired about by the official, both whether or not they were subleased or whether or not the quote-unquote tenants had a contractual relationship with the owner of the property, or the owner of the property would have any reason to know, or know, we love that reason to know thing in the law, that there were more than 3 people residing there.
And did your clients ever know that there were more than 4 unrelated people living there?
At this point in time, the only information that we have to substantiate that is what the town official has put forth.
And your people aren't here to testify, I think, about that, right?
Absolutely not.
I guess the ultimate question.
Can I ask a
question?
Please.
So, your, I guess, testimony here, I guess we can say it's a testimony, is that the rent is paid by these three people. Do you have evidence of that? Is your client willing to show us the canceled checks for each of the months, showing it's just from three people and they've paid?
If
Are
the
you willing to
board
show that? I would
wants
like to
that
see-
information, I believe I can provide it. That's what I've been informed. I haven't seen those myself, but that's what I've been informed of.
All right, and it seems to me that if in fact we don't have, if we do believe what you're saying here, that we actually do have a violation of these three young women here. You could send the building inspector back or actually change the name on the violation to these three women and get them in here and fine them for it. Because it sounds to me like they're renting to five. There's three of them, and they seem to be renting to five people because there's 8 people living there, 8 cars in the driveway, and that would be unfortunate for the town to have to call these 3 young women in here. But
Alan, I still think it ultimately comes down to the property.
yeah, I think there's some legal questions, but
But they're the ones responsible. They inherited this lease, so they should actually
be responsible for enforcing it.
responsible
Absolutely
for-
enforcing the ordinances surrounding the lease. I agree, but what I'm saying is their argument is they inherited a valid, compliant lease, which we all know is crazy, but, because we know that's, but, I mean, this is just crazy.
And keep in mind, there can be a violation without a lease. You can have a month-to-month tenancy without a lease. So if you find that there's testimony on the record that there were, in fact, people renting, more than 3 or 4 renting, you certainly, the lease, while not, the lease doesn't necessarily have to be conclusive of the number of renters or any violation there, because again, you could have 10 people renting month to month and not have a lease under the law.
I think that
That's a good point.
Can I ask a question?
yes.
So, it seemed like in our packet, they were notified and they owe some fees because they walked into a lease, but they didn't become compliant with the town. So they didn't register themselves as a rental, even though they inherited it. They still bought it, don't they have to be compliant like
So
everybody else?
they were sent there was some confusion in that regard. They did not fully understand exactly that they had to re-register themselves. The prior owner, my understanding is, had registered. They were sent a letter on September 11th saying that registration had to occur. Then they were sent, I believe in October, that there was a violation, and then approximately 30 days after that violation being noticed, they paid all the fees in full for the rental registration. So I would make the suggestion that they thought it went for the calendar year regardless of who the owner was. When
So
they
they're
became-
registered now?
Yes, I believe I've showed Mr. Zangari proof of that. And I'm
That's
pretty
correct.
sure- And they paid a late fee as well and didn't question that in any way.
So, I don't know, I've been in real estate for a while. I know that if I'm renting a property, and if I think if there's only supposed to be 3 people renting it, if there's more than 3 people renting it, then they're violating the trust that I gave to them, not anything outside of that. So how is this becoming your reference to, well, they're just doing what they're doing in there. How is the landlord not even caring that there's more tenants in there than what was agreed upon?
When when this violation was issued, which is a snapshot in time that we have to talk about on that day, the lease said this lease and these parties had been in possession of the premises for 6 days. Because the lease starts on September 5th, the inspection and the alleged violation occur on September 11th. So how often should that's a very valid question. How often should a landlord go down and inspect? Is it on a daily basis is quite extreme. Even a weekly basis may be quite extreme. How often are we going to charge a landlord with going down and walking their property?
So, I don't, it's February now.
But
So,
where's
do we have an answer, we have an, like,
we're stuck with the violation is what was known and occurred on that day.
Yeah, so what you're determining tonight is on September 12th.
Sorry, I apologize, I'm saying.
You have the 13th, 12th, and the 11th. On September 12th, did the building official and the building inspector, did they have reason, did they have grounds in order to issue a violation notice for the rental of that property on that date? Whether the violation continues is a matter, frankly, for the municipal court, should it get to that, regarding any fine. But what you're determining tonight is the building official, and, you know, they have their records, they had their inspection, did they have grounds, was there evidence to issue the notice of violation on that specific date? It is possible with any notice of violation to have a valid notice of violation on a certain date and it be cured a week later. I used the mowing the grass. So the inspector could issue a proper violation for not mowing your grass. A week later, the tenant or the landowner can cure that, but that doesn't necessarily mean that the property was not in violation at that point. So your review tonight isn't whether it's a continuing violation. That would frankly be up to municipal court and any fines. It is that snapshot in time, the evidence, both the paper evidence, the evidence in the town files, and then obviously the witness evidence.
thank you, thank you.
Mr. Sado, given the fact, what's your answer? I think I know what it is, that they admitted there were 8 unrelated living in.
Well, that creates another can of worms, because what does unrelated mean in this context?
We're not going down that.
But it was not, that one person who answered was not given an understanding of what unrelated means.
I think we all have a pretty good knowledge of what related and unrelated are.
Well, yes and no in this case, because what if 2 of them are related? There was no question if 2 of them are related to each other, if 4 of them are related to each other. What if one isn't related to one other one, but, well, however many there are not related? And
Mr. Serta, isn't it then, you have on the record testimony from the building official that one of the tenants stated that there were 8 unrelated? Isn't it now your burden to bring in testimony that would certainly counteract or impeach the testimony of the witness?
I think that, sorry, I don't mean to interrupt you, go ahead.
The testimony of the witness, certainly you have the right to bring in any of the tenants, any of the landlord, any other ancillary testimony certainly to contradict the testimony of the town.
Understood, and I think that the question in and of itself is invalid when it doesn't explain to someone and didn't ask them if any of them are related to any of them.
Certainly, couldn't you have brought in that tenant and
Yes, and certainly the town could have asked more appropriate or exacting questions to figure out the details of that, to state to them, are you anyone related by blood, by marriage? But there's no definition in the statute. So to expect lay folks to know what that means without even being able to say, are you related pursuant to statute in the town records, is
So,
a tough
The
Mr.
burden.
Sado,
report-
are you and I related?
The report, if I could,
Are you and I related?
I don't know enough to be able to answer that question.
Okay.
the inspector, in the report, and I'm quoting, said, I asked if they were all unrelated, and they said yes. That's pretty clear.
Well, one of them saying, and I guess that's my point, could 2 of them, 2 sets of 2 be related? So are they all related?
But if that's the case, then you should be presenting that to us.
I-
We're working with what we've got.
Well, and.
I'm not gonna presume that there were two sets of twins living, or two sets of sisters living in that. That's not my job.
I think it's the town's, the investigation's job to vet that out, to ask if any of them are related to any of them. Because what this statute leaves open is a scenario, assuming, and that's another question, is why is, one thing that was not mentioned in the testimony but's clear in this report, it was a complaint of student renters. I didn't, well, I'm curious how we came to know that they were students, or are we assuming that? And then why we asked them if they were students or not. Because that's completely irrelevant and not part of the statute.
Steve, I have a question. So if let's just assume for a minute that there were more than 4 unrelated people living in this unit, and that the facts are true, that the landlord had a lease that said 3 people and did not know that 3 or 4 more people are there. Does our ordinance require some scienter on the part of the owner to know that there's more than 4 unrelated people?
Not to my knowledge, no. It does not, because, again, there's nothing that says that, you know, that the tenancy, again, has to be verified by the landlord. As the landowner, you're responsible for whatever the use of your property. Again, it's almost like that, the equivalent to that would be, would the landlord know if the students are having a party, and therefore the landlord, you know, obviously wouldn't be responsible under our ordinance. You know, ultimately it's the landowner that bears the responsibility of all the zoning code and the property maintenance code, even if, again, if it wasn't them, either it's done without their knowledge or without their consent, they're still ultimately responsible.
So it's like absolute liability. There's no knowledge requirement on behalf of the owner.
Not regarding this. Again, the way our statute reads, again, and the way the property maintenance code and the zoning code reads is, you know, you are, you can't say I didn't know.
Yep.
This may be a silly question, but were the buyers aware of the 4-person unrelated ordinance when they purchased the property? Do you know? I
don't
imagine
know.
they are, they're supposed to be,
I've
they would have to
informed
be.
them of the ordinances now, certainly, but I don't know, I wasn't their closing attorney, so I can't.
Yes,
say
they,
that.
you know, they realized, if we're accepting your testimony, they thought that they were renting to 3 people. Okay. Do you know if they took any action, you know, deemed to have knowledge of that ordinance, and, you know, they're supposed to know the ordinance, did they take any action to, say, remove beds from the unused bedrooms?
I don't know whether
Did they put a lock on those doors so that they wouldn't be used?
I don't think they would have the right to do that, because the lease does give the parties the right to utilize the entire premises. And that lease, they would be breaking the lease if they were to section off portions of the property.
But they didn't remove beds from those bedrooms to help to you know, to make sure that they
I
were
don't know.
compliant with the
I
ordinance?
can only take one at a time.
I apologize. I don't know if there were beds or if there were not beds. I don't know if, presumably when they purchased the house, there was no furniture in it. I don't know if beds were supplied or not. In the lease, it does not, it doesn't address what's in each bedroom or not.
You could continue with this a bit.
In the documents, I guess I would ask the,
Um,
no, I'm sorry, go ahead.
Just out of curiosity, do you know what your clients paid for this home?
I don't, but that's a matter of public record. You know, I do know they paid a substantial sum for it, as anyone who purchases property in Narragansett is now. They
Right.
didn't buy it at a discount, that's for sure.
Especially in the past, well, it's been what, less than a year since they bought it.
Yes, yep.
So, well, that just leads me to believe that if I'm spending that kind of money, I would want to protect my investment and know pretty much exactly what's going on with it. So, but that's just me.
And again, this occurs less than a week after after the lease starts.
That, but that has no bearing on it.
Mr. Kyle, it just occurred to me, one of the reasons why there is strict liability for a landowner is that under the property maintenance code and the zoning code, you have, usually there's a first notice of violation, and then you have either 7 days in some instances, or 30 days in other instances, to cure that violation without ever going to municipal court or ever being fined. So ultimately, before any judicial action takes place, a landowner has to get notice, and then they have a certain period of time to cure unless it's an emergency. Again, it would be up to the defendant to show that they cured any violation on that, from September 12th.
Mr. Serta, did you handle the closing on this property?
No, I did not.
Do you know if they have a mortgage?
I don't know.
Do you know if they did a walkthrough of the property before they purchased it?
I've worked with the agent involved before, and I know that that agent requires walkthroughs, but I can't speak to this specific incident.
Right, and I think you can't tell us that when they were looking at this property to buy it, they obviously must have gone through it, right? That would be the normal thing for a buyer. And they would have seen there's 8 bedrooms.
Yes.
Mr. Serta, to Mr. Marcello's point about cure period, I see that the notice of violation provides a 10-day cure period. The notice of violation date is September 13th. Do you know what your clients did after that point with respect to curing or addressing the issue?
I'm going to state to my claim prior that we're not really here to investigate what occurred after September 12th. We're looking through a very fine lens of what occurs prior to September 12th.
But I think you can address what happened within the cure period. So they had 10 days to cure it. Apparently they chose not to cure it.
Unfortunately, what you're asking me lends into negotiations that I've had with the town and with Mr. Zangari, and those are not something that I can talk about on the record.
Okay.
And
Fair enough.
I apologize about that, but I'm bound by that set of rules and criteria. And another thing that I think that is not, there's mention of a lease during the investigation, but there's no question of whether or not all of the renters are on the lease. To have knowledge to determine if the landlord had reason to know if these folks are transient, if they're temporary, if they're there for a night.
Well, I can tell you what I would do if I was the landlord. I've got a lease with 3 people. There's more than 3. You go down there and tell them they have to leave. You have 10 days to do that. It doesn't appear that that happened in this case.
I can't speak to, again, we fall into the negotiation of why we're unfortunately here tonight, despite significant efforts on all parties' parts to try to resolve it.
So I would counter that, well, while there was negotiation discussions, certainly evidence of compliance would be able to be admitted.
Thanks.
We don't even know if the person that spoke was one of the people on this lease, or one of the people who has a stake in there, has some degree of possession to that premises. They weren't identified. It was a one-off, very short conversation. There was no follow-up to determine if that person continually and regularly resided at that house. We can't even put that person forth here to testify to what they said. They haven't been subpoenaed. We're working off of what was told to a third party, and we can't identify who that person is.
The S word was
Well,
mentioned. Do we have the right to subpoena, right? We have the ability to subpoena.
Yeah, yes you do.
Yes.
We've been down that road.
I don't think we want
No.
to go down that road.
Yes, you legally do.
So my answer to that, Mr. Sedette, would be, why isn't someone here to testify and give us the information to dispute what happened that day?
Because we believe the burden's on the town. It's not our burden to prove a negative. It's the town's burden to prove that the investigation and the evidence that it obtained on that day when it issued the notice is sufficient to prove that this violation was occurring on that day.
So you want me to believe that the person that admitted there were 8 unrelated individuals living in that house, there's a good chance that person just happened to come by and answered the door?
We don't know who that person
Okay.
is. And
Right.
we don't know who is related. We just know that all 8 of them, we can glean we can try to decipher what was said in here, but we don't know. There was no specific discussion about who was related to who and what related means. So you're asking if they're related or not. There was no question of whether or not if they define themselves as a family. We kind of jumped over that part of the statute. They were not asked if they were a family or not. There was no question of whether any of the renters were not students. We just jump right in and assume it's a student renters, and then I don't know why they were asked if they were students or not, before they were asked how many people were living there. Is it only apply to students? Why are we asking that question? I think it's, it's almost as if they're a student. Why is that a relevant question? Why is that part of the investigation? And that would be a question that I just don't know the answer. The answer can't be determined. There was also no follow-up with the rental management company, Key Real Estate, which was mentioned in this, which the parties, the individual who was spoken to said that was the property management, they were in charge of the property, that's who the investigator should reach out to.
Thank you, Mr. Sedette.
Just a couple of things. Ms. Brogan did ask Mr. Surda a question, and just to be clear, you asked him, you said, so I assume your testimony is, I'm paraphrasing. Please remember, Mr. Surda makes arguments. He's not a witness. I make arguments. I don't present the facts. Mr. Eidelman was there. He asked the questions, he heard the answers. You heard from him. Mr. Pimentel wasn't there, but he testified as to the records that he kept in the ordinary course of business in his capacity as town building official for the town. So they're fact witnesses. We're just advocates. So that's, and I know you know that, but I just want to make that clear. And while we're talking about that, there's also the standard. So the standard in a zoning case is the same as in a zoning appeal, which would be, the legal standard would be more than a scintilla and less than a preponderance. They call that, in the case law, significant evidence. Significant means more than a scintilla. Scintilla is like a sliver, very small amount. Less than a preponderance, right? In a normal civil case, you have to prove by a preponderance, more than 50%, more likely than not. Here we don't have that high a burden. We have to show by significant evidence more than a scintilla and less than a preponderance. So you've heard tonight from the building inspector who was there on site on the 12th of September. People answered the door. 3 young women, students. He asked them questions if they were related. They seemed to be candid. And you were very correct to point out in the actual written report if they were all related, to which they responded yes. So please make note of that. He also asked if they were renters. They said yes. So based on the answers that he received, and which, by the way, those people who answered that door, those young women, they had no reason to lie that we know of. There's been a lot made of the fact that certain questions weren't asked. I would make arguments that, in fact, all the pertinent questions were asked. Could he be asked more questions? Sure, you can always ask more. But he asked the ones that needed to be asked. And he received the answers that are dispositive of the matter today. And that is whether or not, in fact, the landowner, not all properties, violated the ordinance by renting to more than 4 unrelated. It seems clear that they did. Mr. Surdot introduced the lease. That's a piece of evidence. I would say this, that lease hasn't been authenticated. He's making a representation that that's the lease. Nobody here came in and said, that's the lease I received. We don't have rules of evidence in zoning. I'm not going to argue that we do. But I think you could consider that, in fact, that hasn't been authenticated in any manner. I took a little bit of time to authenticate the records, because I think it's important. Not just to say, for me to say, here's all the records, and accept that. Mr. Surdot's not going to lie. But again, that hasn't been authenticated. I don't know if that's the complete lease. I don't know if that's the lease at all. He doesn't have personal knowledge. I'm not saying he's lying, but he doesn't know for sure. His client came and said, that's the lease. They're not here to authenticate it. You asked why they're not here. He's right. We have the burden. Right? It's my burden to show that Wayne did the right thing, and he had probable cause to do it, and he did it, and he was justified, and ask you to uphold it. But it would be nice for someone to come in and say, no, that's not true, and that's why. Right? I'm not trying to anti-seed, anti-chair, but it's not a criminal case, and the rules are a little looser here. Now, whether or not you can draw a reasonable inference for the fact that nobody's here to dispute any of this, or submit the lease, or bring a witness, I think you can make a reasonable inference from that. I don't think there's any rule against you doing that. So my closing would be, you've been presented with eyewitness testimony as to what was told. It was recorded contemporaneously. The record and the reports are consistent with what he testified to on direct examination. He hasn't been challenged on cross-examination. He hasn't been impeached in any way. There's been questions on whether or not he did enough. I would say he's done enough. We don't have that high of a burden. This isn't beyond a reasonable doubt. It's not a criminal case. There's a lot of talk about whether there's an intent that needs to be shown. It's not a specific intent ordinance that says you must knowing and willingly violate the ordinance. It doesn't say that. So I would submit that we've shown enough to support Mr. Pimentel's issuance of the NOV. We would ask that you deny the appeal of the appellant.
Very briefly, I would suggest to you that there's not enough evidence in the file, that a statement by an individual who was not refused to be named, we don't know who that was, someone at a door. We don't know if that person was even a tenant or not. That wasn't directly asked of them, in my opinion. We, on the direct examination, it was clearly left out that there was discussions about whether or not these were students prior to the discussion. Prior to any other question, that's the first questions that's asked. Not part of the statute. Hard to understand why that's the first question that's asked. So these parties were not asked if they consider themselves a family. It's clearly part of your statute. No definition of a family in that statute. No definition of related in that statute. These folks were not asked, are you real? Even if we take it to mean that they were not asked any form of told what any form of related means. They were simply asked a bare bones statement. They were not given an opportunity to understand what that meant. They were not provided a copy of the ordinance to know what that would mean. They were simply asked, after being asked if they were students, if they were related or not. If one of them was asked if that person was related to all of them, not if they were related to any of the other folks, not if any of the other folks were related to other ones, and we don't know if that person has that knowledge or had an awareness of that. It's not a discussion that was asked of any of the other individuals. It was a one-off, momentary interaction between parties. There was no question asked of that individual how many of them were students, how they would know they were students, how that individual would know if they were related or not, if that person had personal knowledge of each and every one of those individuals. It's easy to just come in, ask a couple of quick questions, and leave without explaining to and setting that person up to fail. That person is not here to testify. Person is not here to determine what those statements were made, if they had any knowledge or awareness of what related meant, if they were a family or not. It almost appears as if there's a presumption that students cannot be a family. There's a why, whether or not they're students, is the first question that's asked, when it has nothing to do with the statute. It leaves me at a pause. We've provided a lease to you that shows that the owner, on the day in question when this violation occurred, had taken, I would argue, reasonable and prudent steps to ensure that they were in compliance with the rules and regulations. We're not here to determine what steps were taken after that day. We're here to determine if on that day there was a violation or not. And I would suggest to you that there's not sufficient evidence in the file for you to make a determination that they're in full and complete violation of that statute based on an interaction with an unnamed party and an asking of approximately 5 to 6 questions relevant to that issue. And actually in total, only 2 questions that were relevant, and no discussion of whether or not they were a family, which is a key component of your statute. With that, I'll leave you to your decision. Thank you again for taking the time this evening.
You're welcome. Thank you, Mr. Sadette. All right. What's the board's pleasure?
Chairman, members of the board, with respect to the appeal, Nuttall Properties LLC, Plat S, Lot 90, 11 D Felice Road. This is an appeal of a notice of violation of Section 2.2 of the Narragansett Town Ordinance. This matter commenced upon the filing of a complaint by a Narragansett resident on September 8, 2023, in which the complainant filed a complaint with the building official stating that this was and I'll just quote, a 6-bedroom house with 6 to 7 cars parked in the driveway since starting on September 4th, 2023. As a result of that complaint, the building official, I guess, directed Mr. Eidelman to conduct an inspection of that property, which he did on September 12th, 2023. Mr., am I pronouncing that correctly?
Idleman, correct.
Mr. Eidelman
Thank you.
testified before the zoning board tonight that he went to the location of the property and identified himself as a code enforcement and housing inspector for the town of Narragansett, that from a position outside of the interior space of the unit, he interviewed at least one and perhaps several female occupants of that property. He testified that he learned from them that there were 8 students living there and that there were 8 separate bedrooms. He testified that in response to a direct question whether or not the occupants were related or not, that the person that he was talking to stated that they were not related, and none, according to Mr. Eidelman's testimony, none of the other occupants who were situated in and around the area where he was talking with one or at least 3 of these female occupants disputed that answer. They, according to Mr. Eidelman, these young women also said that they were not aware that the house had not been registered. He also testified that there were at least 4 vehicles in the driveway and that they had registrations from different states. Also testifying for the town was Mr. Wayne Pimentel, the building official and zoning officer for the town of Narragansett. He testified that one of his duties is to issue notices of violation of zoning and building ordinances. He also testified that he is the keeper of records for the town of Narragansett, and that he issued the notice of violation in this matter dated September 13, 2023. During Mr. Pimentel's testimony, exhibits, is it 1 and 2, or just 1?
1.
Exhibit 1 was introduced, which was the, well, we'll let the record speak for itself. T1 was introduced during his testimony. Additionally, the, just let me call them the defendant, the appellant in this case. Nuttall Properties LLC was represented by attorney Stephen Surdot, is that how I pronounce it?
Very, very accurate, thank you.
And he advanced an argument on their behalf that the LLC closed on this property in June of 2023 and purchased the property subject to the lease, which was also introduced into evidence by the appellant as appellant number 1, that the lease had a start date of September 5th, and that at least based upon the lease which we have before us, which I will take note was not authenticated by either the occupants or the LLC, does list I believe, three tenants. And Mr. Attorney Surdat made an argument that that it was, I guess, unknown to his client that those tenants may have allowed additional tenants to occupy the premises, taking it beyond the no more than 4 requirement, and that he made a very cogent argument that this violation occurred within like 6 or 7 days of the commencement of the lease. With that being said, however, what I think is telling, at least for me sitting on this board, and I do think that we can take an adverse inference from the fact that the members of this LLC are absent from this hearing and are not here to testify. I think we can take an adverse inference that their testimony would be adverse to them if they were here to testify. And I think based upon the record evidence and the fact that the burden of proof, as Attorney Zangari pointed out, is very minimal scintilla of evidence, which is really just significant evidence. I think this has come up before in another hearing we had, that the burden of proof, which I think that the town has met, shows that there were more than 4 unrelated individuals residing at the property in violation of section 2.2 of the ordinance. And I would, just move at this time. And I would move that the appeal be denied.
I'll second that.
A motion has been made and properly seconded to deny the appeal of not all properties. Is there any discussion?
I'll just state for the record that I agree with Keith's recitation of the evidence that was presented tonight, and the fact that I think we can draw an adverse inference by the fact that the owners of the property did not appear to present any testimony or evidence indicating that the violation was wrong, in that there were more than 4 unrelated persons living in the property at the time the violation was issued. I mean, the lease itself, I don't think the owner can turn a blind eye to the property, and I think the owner has an obligation to ensure that the property is in compliance. So even assuming the lease is valid and that the property owner intended to rent to only 3 people, 3 or 4, I think the owner had an obligation to ensure that the property was in compliance when the tenants moved in. And certainly the, as our chairman pointed out, the rental income from the property, or the monthly rent, which is $7,200, would suggest that the landlord was probably aware that there were going to be more than 4 people living in the house. So I support the motion to deny the appeal.
Anyone else? All right, all said. All those in favor?
Aye.
Aye. Opposed? That motion carries 5-0.
Thank you, Mr. Chairman, members of the board, for your time.
Mr. Zangari, thank you. All right. I will accept one.
So moved.
Second.
All those in favor?
Aye.
Aye. Opposed? That motion carries 5-0. We are done this evening.